probably about 40 minutes or so for questions. So I'm going to take a few. Yes, who's got the mic?
My name's Breach Foyle, Ballymurphy Massacre Committee. I was just wondering if anyone could put a bit of light on that for us. We have asked Cameron to give us an investigation into 11 people murdered over a period of 3 days in 1971, which he has told us it is not in the public interest. But we can't understand, he won't explain why. We have asked different Secretary of States what he has meant, and he doesn't tell us. But we can't understand why an investigation, because you have one person who only had a flesh wound, but when his autopsy reports come through, he was executed with a bullet behind each ear. You have a man found with 14 bullets in him, not in him, but he was shot 14 times. And this could go on and on. I can't understand where he's coming from. I was wondering if anybody on the panel could explain it.
Okay, thank you. Any other questions? Just one here.
Thanks. When Paul was speaking, I hope people were suitably astounded when he told the story of the young man whose case was overturned in the appeal court, who had signed a statement and served a sentence for something which didn't happen. That should terrorise us. What it brought home to me was the relationship between prosecution, the judiciary, the policing in the past. I almost feel like the conversation here, it should be dodgy ground for people who have given unconditional support to the structures of the state. They must be questioning themselves just at the moment, because that brings home, we're talking about young people here under the age of about 17 or 18, and they were being treated like this, and signing statements, and no other evidence produced against these young people, and they're being prosecuted and put through the courts and into prison. Now, the question which has been run about, I'm a Republican from a Republican background for years, and the question which has been run about in circles for years was, what was ever done about the police officers who said that that young man had willingly said that he had done that? Now that's only one, we'll just take that as the one situation, and I have absolutely no doubt with my own life experiences and speaking with these young people, there are many, many more of them. It's just, if we take it as a concept, what has been done about that? What could be done about it? And if nothing was done about that as an example of things, why not? And is there anybody going to do something about why nothing was done? It's a major factor in our past.
Thanks, Michael. Daniel, over here.
Thanks. I have a couple of questions for Barra, although one of them isn't who stole the last page of your paper. I'm sure we'll find that out in due course. The first question was around definitions, really. I noted from the last presentation the definition of public interest in the Code for Prosecutors on one of its grounds, its last grounds, defers to national security grounds. So I was wondering, is there a definition within the Code or otherwise operationally within the PPS that actually defines national security? And then in that context, what that might mean. And the second question is the subject, again, a number of the presentations, a number of times this morning as well, came up of the role of informants. And I have a specific question on the SOCPA legislation, the Supergrass legislation, as it's often referred to. A couple of observations. One on it is that many of the recent cases either involve informants themselves as assisting offenders, alleged informants, or involve certainly examination of crimes where informants, or indeed by extension the handlers, are implicated. And the second observation about the legislation is that although the formal role in striking a deal with the assisting offender seems to be vested in the PPS, in practice, a lot of it, and I have the most recent policy directive that was published by the PSNI on the matter, I think it's currently under review, in practice, a lot of the process seems to be delegated to the PSNI, and in practice as well, there seems to be quite a heavy role for C3, the successor to special branch, in controlling the flow of evidence and information that goes in and out of the debriefing cell. So my question to that is, what safeguards are in place, given the potential conflicts of interest there, to ensure that evidence that relates to informants and the handlers isn't actually filtered out or excluded before it reaches the PPS in those cases?
Okay, we'll take one more. Paul over here. Kieran, I'll come back to you.
Thanks, Don. I suppose I've one question for the panel and another question for Barry. Paul O'Connor with the Pat Finucane Centre. I don't know if you noticed some of the recent documents that were revealed, and it goes back to your talk about the public interest, which show that the Attorney General in the 1970s in London was making the decisions personally on the prosecution of soldiers, and that he gave a guarantee to the GOC of the Army at the time that before he would make a decision, he would ask the Army for their views of any public interest issues concerning the prosecution of the soldiers. And the background briefs show that the issues that the Army were discussing were essentially that this was bad for morale, that would make it impossible for them to carry out their duties and so on. What the panel's response is to that very peculiar view of public interest and the fact that the Army was given prior access to prosecutorial decisions. The other question is specifically for the Director, for Barry. There is obviously the whole issue and controversy around when files are forwarded to your office or when they were filed to the prosecution service in the past. What was the nature of the files? What kind of investigations were done? I'm wondering what your reaction would be if, for instance, there was evidence that the RUC quite improperly used its own discretion in cases involving killings of civilians by the Army and did not at the time forward any file to the prosecution service. And if no files were submitted, when you spoke today about the family's right to justice and about that triangulation of the victims and so on, do you think that your office would be open to the idea of approaches being made to it by families now where there is firm evidence that no file was ever submitted and that was in fact quite improper in contested deaths? Thank you.
Thanks, Paul. Okay. We'll start with Gordon at the end, and just in relation to that last question, which was to the whole of the panel, which is the RUC. What would you say if it was discovered that the RUC used their own discretion in not forwarding files?
That was for Barra. I'd be very happy to start.
Starting with Paul's question.
Starting with Paul.
With the end and
Yeah.
moving backwards. Okay, Paul, that's the issue of I know the sort of material you're talking about in terms of the early 70s, and let's put it this way: there were a number of files concerning soldiers which were forwarded to the former office of the DPP, and I'm aware of those files. I think your organisation has alerted me to some of them, and there are other organisations looking into that whole issue at the moment. I have to say that is one area where there may be a gap in terms of the investigative responsibilities, and which I think is going to have to be addressed, certainly in terms of any alleged wrongdoing, and this is touched upon by, I think, Mr. MacDonald, of police officers in the taking of evidence and in the conduct of cases. There is, of course, in the form of the police ombudsman, an investigative remedy. In terms of how the military in the early days of the military intervention conducted themselves and how they might have been investigated, there is an issue, and there's no doubt about that. And unless or until there is a decision by somebody who decides these things to thoroughly investigate that issue, I think it will remain unresolved. I know that HET throws up the files and then I think some of the material you're referring to was perhaps thrown up in that context. But the HET doesn't have an investigative remit, as I understand it, in respect of the military, or doesn't consider itself to have. So I don't know if Mr. Cox is still here or not, but he might be able to shed some light on that, because this would be an interesting question for him. But certainly from my perspective as Director of Public Prosecutions, I have observed the absence of any significant investigation of that area. So, but I'm powerless to do anything about that, really. Well, I'm not powerless to do anything about it, but let's put it this way, I'm actively considering a number of options, but I'm limited in what I can do about it, but I'm not unmindful of the difficulty. Let's put it that way. So, had you a quick follow-up? You had?
Just very briefly, there is one particular discrete issue.
Can you wait a second, Paul, to get the mic?
I can't get into individual cases, Paul. So
No, I'm not asking you to do individual cases, but there is another discrete issue that has arisen, and that is where there's evidence that no file was ever submitted.
Yes, sorry about that. I've skipped that one. Well, look, my problem is if I have no file, there's nothing I can do about it. But and again, it's a question of resources. But as I've said, we will look at any file when we get it. But it wouldn't surprise me if there were quite a number of incidents involving the military in the 70s where no files have been submitted. But again, I'm not able to comment other than that. If I get the files, I'll have a look at them.
Okay. Gordon, do you want to address Paul's question on the issue of public interest in the attorney?
My understanding, and I double check this with Paul as well, my understanding is that the Attorney General, there's a Shawcross Convention, I think it's called, so if there's an issue arises before the Attorney General that cross-cuts governmental interests, the Attorney General will take soundings across government. That happened in the Corner House case, in fact. So I suppose if the Attorney General consulted through the MOD and other government departments at that time, that's probably consistent with the convention. If it was the case that the Attorney General was only consulting with the MOD, then that would have been out with the terms of the convention. That's not an answer to that, that's just a statement of what I would know about it, Paul.
Okay, Paul?
Yeah, just in relation to Michael's question, and I'm also conscious, Donald, I don't want to intrude on your role, but there's an outstanding question in relation to Ballymurphy as well. But on Michael's question, I mean, this sort of issue about a lack of accountability in relation to police officers, of course, has been one that's been outstanding for some considerable time. And stepping outside slightly the CCRC role for a moment, I mean, this is something when I was in CAJ would have worked on quite a lot, comparing the number of complaints made against the police in a year vis-a-vis the amount paid out in compensation. And while considerable amounts might have been paid out in compensation, very, very few complaints were upheld. So there was, it appeared, an accountability gap. And looking back further into the 70s and 80s, that gap was probably, one could say, even wider. What the CCRC work has done, I think, is provide a partial picture of what happened and a bit of a snapshot of what was happening in the holding centres, particularly with young people. And they were under 17. That was the definition at the time, under 17. So some of these cases involved 15-year-olds. What's interesting, I suppose, is the CCRC has been able to obtain information that suggests that something untoward was happening in the holding centres in relation to quite a significant number of cases. But the CCRC's role isn't to prosecute, it's to see is there evidence on which they can refer back to the Court of Appeal, and they have done that in appropriate cases. It doesn't appear, from what I've seen in the very limited time I've been there, while there's material to suggest that lots of individuals, including young people, did sustain injuries in interviews in the holding centres. The material that I've looked at doesn't suggest that anything happened as a result of that, although complaints were lodged. And certainly in some cases, to be fair, what seems to have happened was that the DPP at the time, in some cases, took decisions not to proceed with prosecutions because of the medical evidence. But those were very, very few and far between. It seems from what I think, from what the CCRC has looked at. So what I can't answer is whether or not the DPP at the time then took what appears to be quite a logical step and said, well, if there's sufficient evidence here that causes me such concern that I'm not going to prosecute this particular individual, did he then ask the police to investigate that with a view to bring in criminal charges? Because, of course, you know, if there was medical evidence, that would suggest that something clearly happened, which could have led to criminal charges. And in terms of the sort of follow-up, what could be done? I mean, I think that's a very, very difficult question for all of the reasons that we've heard all day. You know, it's difficult enough in cases involving killings to access material from back in the 70s and 80s. In cases like this, it's going to be much more difficult. Now, as I say, the CCRC has been able to in some cases, but there are other cases where material just isn't around. You know, where requests for material come back and information has been destroyed or lost or whatever. So I think that's a problem.
Can I just add something there too? To what Paul's saying is that, of course, there's a very big difference between deciding that you can't prove a case against an individual beyond a reasonable doubt because there might be some substance to their allegations of ill treatment, and proving the ill treatment beyond a reasonable doubt in itself. They're two very different issues, and the test for prosecution in circumstances where old convictions are overturned because of allegations of ill treatment, which are probably substantiated, is not necessarily met. So that creates a difficulty. One does not necessarily lead to the other. So I would just point that difficulty out.
Paul, do you want to come back to Bridget's question about the Ballymurphy families?
Yeah, I'm not really sure that I can deal with that question, Bridget. I'm not sure who on the panel could.
Barra.
I can't help on the Ballymurphy issue. I just can't. It's not within my remit. I'm sorry.
I think your question, and I think it's really important in terms of the debate and discussion that we're having and will continue to have in terms of how we deal with our past, because it's obvious that there are families, many families out there that still have questions that need to be answered. Unfortunately, there's no one on the panel here that feels that they have that remit in order to answer that question for you.
Barra Bridge is my name, sorry.
Would your office at the time have been able to investigate into the killings? Just that a woman was found dead. Why was she killed? And then the army put out statements that she was an IRA woman.
I know. I understand your frustration, Bridge, but a couple of problems there is that it was a very long time ago, and
tell me about it.
Yes, I know, but the difficulty is that the other difficulty is that the DPP's office, as the PPS now, never had an investigative function. So it's not something that's simply within our remit. So there's just nothing I can do about it. And while I might have private views about these things, I would be, I think, wiser to keep them to myself and only give views in relation to prosecutorial issues. So I understand where you're coming from, but it's a real difficulty. And one thing that I can't do is start now systematically going through all the files over the last 30 years, because then I wouldn't be doing my day job, which is to get on with prosecuting in the present. So I rely on the other agencies to throw up the information for us to take a view on whether or not there should be a prosecution, and we do the best we can. So,
Thank you for your question, Breach. Gordon, just to come back to Daniel's questions on the definition of national security as contained within your paper, is this something that you've looked at in terms of the definition?
No, only insofar as national security is another, as you well know, another loosely defined term. So if you take, for instance, the Convention, Article 8 of the European Convention, Article 8, Paragraph 2 lists the grounds on which the state can interfere with, or place limitations upon an individual's rights. They're often loosely clustered together under the heading of public interest, and they include national security. And if you can define it, you could bottle it and sell it.
Barra, could I come back to you on that? And also,
I was afraid you might.
Yeah, and Daniel's other question, which was basically around where the lines are drawn when it comes to assisting offenders, and what safeguards are in place to ensure that you have primacy, I suppose, when it comes to that role.
Okay. Dealing with national security first, it is in the eye of the beholder in some ways, but I can tell you I'd certainly be taking a fairly robust view in terms of any argument put to me that it's in the public interest, not where the evidence is clearly there, to prosecute in the interest of national security. But I think more often than not that issue arises in the context of the Article 2 right to life, which is not to be confused with national security. So this issue of informants and the Article 2 duty on every public body to protect the right of an individual life applies to that of an informant as much as it applies to anybody else. So for that reason, from time to time, prosecutions are not taken because in order to pursue it publicly, that's it would expose an informant to risk, and informants are as entitled to the right to life as any of the rest of us. And the consequence from a prosecutorial point of view of a decision like that, which has occasionally to be taken, is that the prosecution is not taken. I'll come back to some CCRC situations in a moment in another context. But the second point there in terms of safeguards in respect of the intelligence that the PSNI might have in its possession in the context of SOCPA. All I can say is that I have a body of extremely experienced prosecutors in our Central Casework Division who are very highly trained to examine that material whenever it is relevant to a particular case. And the disclosure decisions are made by those individuals as lawyers independent of the police. I suppose one can never be 100% certain that you've been given everything that exists, but certainly these lawyers are very highly trained and will spot, I think, by and large, if something hasn't been handed over. But again, there are limits to which the prosecution can go in order to safeguard against that. But certainly, difficult disclosure decisions have to be made in that context, and they are day and daily. But I can assure you that there are a body of very highly trained lawyers who know what they're doing in that regard. But we do depend upon the honesty of the people we're dealing with. But it's difficult now. I mean, there are better safeguards in place. There are, particularly in respect of the regulation of investigatory powers. In recent years, there are very strict controls over how informants are regulated, how the dealings with informants are recorded, whether or not investigating officers, for example, are allowed to have any contact and so forth. So all of this is in the public domain and is open for scrutiny, but it's a different legal landscape now than it might have been in the past. So that's one of the reasons why I've got a considerable degree of confidence that when certainly the lawyers in the Public Prosecution Service are looking at this material, they can be fairly sure they know that they're getting everything they're supposed to be getting, and if they're not getting what they're supposed to be getting, can pursue that because they check the REPA regulations. So I think those are those two questions. I haven't seen a national security issue yet. Of course, national security doesn't lie with us. It lies in London, and the Attorney General of England and Wales retains, as in his form as Advocate General, discretion over prosecutions in the national security context. It's not something that lies with me as Director of Public Prosecutions for Northern Ireland, and nor have I come across in the 18 months in which I've been there where there's been any issue of national security.
Thanks. Kieran?
Thanks. I have questions for Paul and Barra. Paul, on the CCRC, as you know, ex-prisoner groups here have been quite successful in mobilising the ex-prisoner constituency and for a range of things, including taking cases to the CCRC. So I suppose my question is, can the CCRC cope with the level of cases that are forthcoming, conflict-related cases from ex-prisoners? And my question to Barra, and it relates to some of the points that Gordon was talking about in terms of public interest and prosecution. Gordon, Barra, two things on that. One, I note from the prosecutorial guidance that Gordon usefully provided on page 4 of his paper. Number one of that is about whether the court is likely to impose a very small or nominal penalty. I take the point that it's the court imposing that penalty. But I'm wondering, does your office ever become exercised, for example, in deciding to take a historical prosecution by the reality that if it's a pre-1998 event, that person, if successfully convicted, is only going to serve 2 years. If they're held on remand, it's possible that they may, in effect, walk free from prison shortly thereafter, after the prosecution's been effected. So I take the point that it's the court imposing the sentence, but I'm just wondering if that features in the deliberations of the office, the fact that in reality people are going to serve very short penalties as a result of that. And the other question is, I was actually asked earlier on by a delegate to the conference from a group from East Belfast, and it relates to what are colloquially known as supergrass trials and the issues around supergrass trials. And in particular, I think that the question is around, in a context where we know that historically and more recently, a lot of these cases tend to fall apart, that they're very expensive to take and so forth. But in a context where a reasonable chance of success is one of the criteria, how come we still have supergrass trials progressed? I think that was the gist of that question.
Okay.
Do you go first or me?
Just at the, I'm just taking a few, if you don't mind. Just the table over at the back there.
Hi, my name is Mageean. I work for Bridge of Hope, which works with victims and survivors of the conflict. And I've been specifically looking at the legacy work and the aspect of that. I'm also a former journalist of nearly 15 years as well, and for me the public interest debate is critical, particularly if we're talking about dealing with the past processes. As a journalist, FOIs are regularly blocked. The interest and the public interest, and also departments of stormont, regularly block your FOIs, and even if you do get them, they're redacted. The same for the PSNI, the same for the Ombudsman, the same for anyone. It's just constantly at every level, your efforts to address the past or to get at some form of the truth are frustrated at every juncture. It just seems to be persistently happening. And I suppose whenever we had a conference by Lord Robin Eames recently, and he had huge access to to amount of data related to the conflict, it's probably the consultative group in the past. And he said some of it will never see the light of day. None of it will ever see the light of day. Some of the data and the information he was given was so privileged. But he said some of it will. He goes, I don't know who will make the decision to release it and when, but there's some terrible things that have yet to come out. So I suppose my question is, and it would be great if the panel could address it, would be if this is serving the public interest, then how can we ever effectively get to grips with dealing with the past if we can get at the truth?
Okay, huge question here.
Hello, my name is Robert McCann. I was part of the McGurk's Bar massacre group. But my question relates to the wider stuff that Barra was talking about in terms of what is the state, and then the issues of obviously the issues of public interest and dealing with the past and how public interest has gone and has been used. But Barra, when you made the point there that the DPP, or what was the DPP, the PPS now doesn't have an investigatory arm till it, but is relying on evidence being presented to tell it. And for me, part of the problem with the past is that the agencies had a too cosy or too close relationship that made up the state. They were almost incestuous in some ways. And a concrete example would have been the Stevens case or the Stevens report. We had Stevens 1, Stevens 2 and Stevens 3. They finally came to a report which was published in April 2003. And part of the Stevens team, as you remember, would have been Hugh Ord and Dave Cox, who spoke this morning. And they recommended 25 prosecutions, some of senior police and some of senior British military intelligence. But that report, if you like, Stevens sat with the DPP as it was from 2003 until 2007. And then a statement was issued saying that in the public interest, it was no longer applicable that these prosecutions could or shouldn't go ahead. So I suppose my question is, one, is it possible now to revisit that? That here was the longest serving inquiry in our legal history, was presented with findings, which then went to the then DPP, and then who refused to act and sat on it for 4 years, and then the politicians come out and issue a statement that, so in dealing with the past, do we not have to deal with the inadequacies of both the DPP and then the other agencies involved? So, thank you.
Okay. All right. Paul, do you want to go first with CCRC, and can you cope with the number of cases?
I mean, I think that. I think the short answer to that is yes. The CCRC can cope. I mean, as I said, probably the level of applications from this jurisdiction is lower than might be expected. Although there's a significant number of convictions or applications relating to the conflict. The CCRC has, I think I flagged up in the talk, has seen a massive increase in applications recently, but not from here. And as a result, there is pressure on the Commission building, and there are issues around waiting times. And the Commission tends to rightly prioritises cases where the applicant is in custody. So that will mean for people who've been released from custody probably slightly longer waiting times before their case is dealt with. And I'm not sure, I think I spoke to some people in the Commission in anticipation of today about whether or not there had been any significant increases at any particular time in relation to applications from here. And there was a feeling that round about 2006, 2007, there had been a significant increase. And I imagine a lot of that did relate to cases of young people, as the cases that I've mentioned. That seems to have dissipated somewhat in recent years, and probably one of the reasons for that is the judgment from the Court of Appeal here, the Brown judgment, which, as I said, seemed to roll back on the previous approach that the court had. And as a result of that judgment, the Commission wrote to quite a large number of applicants saying, I'm afraid that we're not going to refer your case. So if there was a sort of crescendo building in relation to those cases, I think that's ebbed away somewhat. But certainly, the Commission is open for business and ready to take on any applications that might come in from here. But the reality is, any of these historical cases, certainly dating from the early to mid-70s, are going to be very, very difficult to deal with and will take a considerable amount of time to deal with as well.
Thanks. Gordon, just in terms of Anya's question on public interest, the public interest debate and the access to information, because you referred in your presentation to public bodies and public bodies acting in the public interest. Have you looked at this in any great detail in terms of access to information?
I'll not say I've looked at it in any great detail because I make myself a hostage to fortune if I say that, but I do have one or two comments on it. One is the FOI, of course, isn't NI specific, and it is couched in public interest justifications for not disclosing information left, right, and centre. That's a problem with FOI. You asked the question. I think your question was, can we effectively deal with the past if we can't get to the truth, get access to information? And is it Robert? Sorry. Yeah,
Yes.
if I can just dovetail up with Robert's question for a second, and I'm not at all trying to be evasive on points of law, but I think essentially, and I'll gladly defer to Kieran on this, essentially this is a question, or those are questions I think that tie in with the model of transitional justice that is in place in NI. So you have public actors who haven't been displaced as a result of the end of the peace process, and you have habits of mind, you have tendencies within institutions. There hasn't really been a clean break with, let me start again, the Good Friday Agreement wasn't entirely a clean break with what was there in the past. So probably that's inevitable in the short term. Yeah.
Can you hold on one sec till the mic comes over?
Sorry, I'm speaking into my phones. Where we have developed a transitional justice model, and it's for grassroots communities, and those are specifically the questions that are coming from grassroots communities about public interest. Though we've worked with communities from Mount Vernon, New Lodge, Tigers Bay, Falls and Shankill, and we've ran 3 different programmes, and you know these are the kind of the questions that are there, you know, issues of trust in judicial systems, in prosecutors, in retrospective judicial processes, but also current processes, particularly. That was the strong feedback from the community in Mount Vernon in relation to HET and Supergrass trials, etc., etc. So for me, I think in the context of this discussion now, the public interest is just consistently used, and it was referenced by our transitional justice students as a consistent block to truth. And if you're saying that because the partner in the agencies associated with the Good Friday Agreement 15 years ago haven't, you know, made that, there hasn't been a severance as such, then how do you progress that?
Well, I genuinely don't know the answer to that, so, but I will ask you a question in return, so don't hand back the microphone. Have you had any success going through the Information Commissioner's office and that route by way of trying to get access to the information?
Well, I mean, I suppose in terms of sort of the FOI request for me, I was a journalist for 15 years, nearly 15 years, and I did try various different avenues. Now, for example, there are groups, particularly in this room, who do it much better. I mean, I was just a person by myself, you know, but the Pat Finucane Centre has, you know, the expertise in this field. You know, they consistently push on the door and try to get the data and whatever, but I mean, I just think that for myself, it's, you know, I'm kind of not in that business where I'm submitting FOIs every day, but, you know, there are families, and I know, for example, the McGurk's families, you know, still consistently lodge FOIs and don't get anywhere, and if they do get anywhere, it's redacted and it's pointless.
Okay, thanks, Sonia. Can we come back to Barra? Barra's going to try and address all of those questions together.
Starting with Kieran, and you raised 2 points, Kieran. The first was the issue of that definition of public interest concerning small penalties. I think it should be clear from some of the cases we have taken that is not an inhibiting factor. We recently secured a conviction concerning the murder of a young Catholic girl in the 1970s, in which the perpetrator will serve as 2 years, but that wouldn't in any way have inhibited the prosecution. Similarly with other historical prosecutions. And there are a number that we're looking at the moment. So I think what that provision is intended for is a situation where, say it's a fairly minor offence, and the penalty would have been expected to be very small, yet the scale of the prosecution would have been, it would be enormous, and that's what that's intended for. So it's a proportionality issue, and certainly no incident from the past which would attract a significant custodial sentence over the 2 years would be considered as one which wouldn't be prosecutable. Secondly, you raised the supergrass issue, not a word I'm supposed to use. Assisting offenders is the modern term. We've had the Stewart's experience. We've studied that. The next one that was a decision that was taken before I came in. The one that has been taken since I have come in respect of the murder of Martin O'Hagan, as you all know, I took a decision not to rely on the evidence of the assisting offender in that case. That was a decision taken on the merits of the individual case. There's another major one looming, and I'll take each one as it comes. There are other decisions around the SOPA legislation which will come into focus in the coming weeks in terms of the power to refer back to court for review of sentence. So there are decisions that are imminent in that regard. So the debate in relation to SOPA will continue, but the legislation is in place. If I'm presented with evidence from an assisting offender, it will be rigorously examined with a view to whether or not it will stand up. Just because the last one didn't doesn't mean that the next one won't. So they'll one case at a time. In relation then to the points raised by Anya, in relation to FOI, Anya, I mean, I have an FOI team who spend a lot of time digging out information on FOI requests. So we try and meet as many as we can. And try and facilitate people. And I think I also have gone out of my way to try and meet individuals and give them as much information as possible about prosecutorial decisions, and have been involved in the writing of long, detailed letters to people about reasons in the past and the present. So we do our best there, but freedom of information is difficult because, it's so time-consuming. Robert, you've raised a difficult issue here in the context of the decisions that were taken by a predecessor in relation to Stevens. I'd like to distinguish between the prosecution actively participating in taking a decision whether or not to prosecute something from the past when we've been given the information, and the issue of reviewing previous decisions. There are two quite distinct issues. The first one's easy because, as I've said, if some investigative body, whether it's the Ombudsman or whether it's the PSNI, gives us the material, we'll take the decision whether or not it's good enough for a prosecution. I think there's an issue of policy concerned with the other issue which you have raised, which is whether or not a new Director of Public Prosecutions ought to revisit all of the decisions of his predecessors. I think as a matter of policy that would be wrong, because where do you begin and where do you end? And if you do that, when do you do the job you're supposed to be doing at the moment? So it's a difficult one, and there will be a huge variety of decisions that predecessors have taken about which people are not happy for one reason or another. But I don't think it would be appropriate for me as a new director to start saying, okay, I'm going to pick this one or this one or this one and redo that decision. Those decisions have been made, for better or for worse. But if new material comes forward in respect of those issues as a consequence of some other investigation, which gives cause to review a prosecutorial decision, well, that's a different matter. But I think as a matter of policy, that would just, I wouldn't be prosecuting anybody in the present if I were to start doing that. And so that's the reason for that. So,
okay. Take one more round and then we'll break up for coffee.
In terms of the notion that people can be jailed for offences before 1998 for 2 years, and it's in relation to licences. Because clearly at the moment there are at least 2 people who are in jail because of offences that were committed in the 1970s, and they're solely in jail for those offences because it has been said that they broke their licences. But the difficulty with that notion of breaking licences is that the evidence is not before open court, so who knows what the evidence is. So just I'd like a comment on that, please.
Any other?
Sorry.
We'll see if there's any other.
Hi, this is a question for Barra. Sorry, I'm Carol Wood from the Centre. Barra, you said that you're not happy about the idea of revisiting previous DPP decisions on prosecutions, but you also said, can I clarify, that you are willing to look at the files or get your staff to look at the files and perhaps give families explanations for why people weren't prosecuted or why for example, a policeman's status as a policeman was not disclosed to a court, that sort of thing. Am I right in saying that's where you stand at the moment, that you are open to meeting families, discussing with them previous decisions, or at least getting your staff to try and give an explanation why decisions were made, which is separate from going back and maybe initiating a prosecution when one wasn't taken in the past?
Okay, thanks, Anne. Any other questions? There's one just at the very end.
Thanks very much, Declan Kearney, Sinn Féin. There's a bit of a truism, and it has much more currency today than perhaps at any stage before, and that is that we contest our future because we contest our past. In some ways, that takes us to the heart of the discussion that's been facilitated today. So congratulations to the two universities and to the rest of the host organisations in putting this event together. And to all of the contributors, I think it's been a very worthwhile and informative event. I suppose the hidden aspect to much of the discussion today is that we have had a prospectus on where we're at and the future. But just in the same way that we contest the future because we continue to contest the past, equally, the re-engineering of so much of the justice system that has been a feature of our journey in the last 15 years also remains beset by the past. So the reality is that though we hope that it will be a diminishing reality, a dark side continues to infect and contaminate the ability of the justice system to work with best and maximum effect. And the reality is that policing continues to be challenged by the reality of reformers and those opposed to reform, hawks and doves, to coin the phrase. And the Department of Justice also reflect some of that reality, where those who have migrated from the old system into the new continue then to try and place fetters on the continued journey of transformation that we're all embarked on. And I think that is one of the keyholes that we need to look through as we try and interrogate the kind of issues that have come up during the course of the afternoon and to some extent this morning. In that point about the re-engineering of our justice system, there are big fundamental strategic questions that we'll all eventually have to face into. And it's clear that the modalities are there within the justice system to address what may be required in the future to ensure that victims, survivors and we as a society gain full access to truth recovery. But there's a juxtaposition in relation to the question of truth recovery, and that is whether we can in fact get justice and truth in equal measure at the same time. And that's a very big imponderable. But it does throw up, and I'll finish on this point, Chair, it does throw up a big strategic choice and decision that we are going to have to make. And in the process of whichever way that goes, it will require increased re-engineering and remodelling of our justice system in the time ahead, whether we can have both or whether we get one or the other. But it will throw up strategic choices for the justice agencies and the justice system in respect of how it equips itself to allow our society to continue on the journey of transformation that is yet to be finished.
Thanks, Declan. Okay. Paul, would you try and address the issue about licences?
I think Gordon wants to answer that, Don.
Conditions of license.
You're quite correct when you say that there are these incidents where individuals are being recalled on licence, and there's a singular lack of transparency in relation to the reasons why that is. And that's the realm of special advocates, and that's, for the moment, that's how the legislation deals with it. So special advocates will be appointed to see information in relation to the individual, but the individual query is the individual given enough access to the information. I don't think very many civil liberties or human rights lawyers are pleased with the special advocate system. Special advocates themselves aren't even pleased with the special advocate system. But for the moment, that's how the matters are being addressed.
Phelim raised the issue of licences. Well, as prosecutors, we deal on evidence only. The issues concerning the withdrawing of individuals on licence or bringing them back into prison is a matter purely for the Secretary of State. In relation to one of the people you're talking about, there are outstanding charges which have been brought in a court of law. That process is yet to be completed, but those decisions are nothing to do with the prosecutorial system in terms of the licence. And you've raised an issue about giving of reasons. I've spent a lot of time giving detailed reasons in some very old cases. The files are very difficult to locate. I think in one occasion which you sent in to me, a file was located, but it turned out to be the wrong file. I had to do a deep search for a related file, and I think that has now been found. So I do my best to respond to those, and I'll accept criticism for being slow, but that's simply because of the sheer weight of the work that one has to do in terms of what's going on, and that's not necessarily of much help to the people who are asking for the information, but certainly I'm very open to giving it. But it is a big resource. But that's not to say that I'm not willing to try and do that. And I think my difficulty is that I try and do it myself too often. But in any event, Declan, well, I think yours was more of a very interesting reflection on where we are than a question. But I think you touched on towards the end of what you said I think really one of the themes of what I had to say, which is that we have a choice to make, I think, at this juncture, either between justice and truth or some form of combination between the two. Eames Bradley made a Herculean effort at trying to identify how we might deal with that, and it has not been followed up for one reason or another. If and when those of you who are charged with political responsibility to arrive at such a solution do so, I think major strategic decisions have to be taken and resources have to be found, and a great deal of energy and will has to be found to address it. And certainly we're willing to play our part as prosecutors, but I think we must stick to rigidly to the prosecutorial decisions based on evidence, and sit outside that process unless we're asked to engage with it by the provision of evidence to us. But certainly I'm very willing to engage in terms of the finding of a solution, but I think a lot is expected of both the investigators and of prosecutors in terms of the past, which we cannot deliver unless or until the choice is made either to go down the South African route or something like it, or to resource a thorough investigation and prosecution of the past. And again, that's a decision that the politicians who we as people elect to take those decisions must take on our behalf. But
just a very brief couple of points. I mean, just on the issue of licences. Actually, one thing, I mean, you pointed up the two cases. One thing I suppose to also point out is that given the number of prisoners released on licence over the years in relation to paramilitary convictions, actually the number of recalls is very, very low. So I think that's something to bear in mind. There are lots of prisoners now out on licence, what might be called ordinary prisoners, and they're recalled quite regularly and subject to a licence process. So it's not an extraordinary process. And just coming back to the issue about dealing with the past and police officers and some of the problems that we've discussed this afternoon. I mean, Barra pointed out earlier the difficulty in terms of prosecuting a police officer to a criminal standard in relation to something that happened 20 or 30 years ago, and of course that's absolutely right, and that is a difficulty. But I think it's important to ventilate some of these issues, and in that context, I think today has been a very useful exercise, and I'd just like again to thank the conference organisers and to echo what Declan said in terms of how positive I think today has been in raising some of those issues and allowing us to try to get to the bottom of them.